Alright, Chapter 3, Fundamentals, Real Estate Law. Essential matters to learn this chapter. Adverse possession allows a person who uses another person's property to gain ownership when using actual, open, notorious, exclusive, hostile, continuous, long enough, set by state law. Annexation and the manner of attachment of personal property to real estate. It's important to determine whether the object attached becomes a fixture part of the real estate. And annexation is also a process applied by city to grow by including adjacent land. Chattels are items of personal property, including auto, clothing, and movable furniture. Color of title, which also appears to be good title, but it's not true. Community property, a form of ownership recognized in 7 states, most of Spanish origin, property acquired with the husband and wife, joint effort during the marriage, owned one half each, property either owned separately before marriage or inherited during a marriage remains separate property. Condominium or condo, a form of ownership whereby a person owns a specific unit, can mortgage it, has a right to use common property jointly. Constructive notice occurs if the instrument, such as a deed, is recorded with the county courthouse to give notice for the world's existence. Cooperative, a co-op is a form of ownership whereby a person owns stock in corporation, receives exclusive use of the specific units, rights to use of common property jointly. Co-op and condo owners may pay assessments. Corporal refers to the property that is tangible. Incorporeal refers to intangible property. Devise is transfer of real estate by will or last testament. Bequeath is a transfer of personal property by will or last testament. Dower rights is a statement. States recognize that giveth a wife or a child the interest part of his deceased husband's estates. Few states recognize husband rights. It's called courtesy. An easement. Easement is a right to use property of another. Use the property of another for a specific purpose. The eminent domain is the right of the government to give the government authority to take private property from public use. Process is called condemnation. Condemnation, which requires payment of just compensation for the property taken. Erosion, gradual removal of land by nature. Avulsion is the sudden removal of land by a hurricane. Accretion is the natural addition to the land. An estate is the degree of the quantity, nature, extent of the interest of the person over the property. There are many types of estates. A life estate is explained with the death of the life of the tenant. The remainder man acquires ownership of the property called the revision. The per autre viva, or for another's life, is a type of life estate that ends on the death of someone other than the life tenant. Fee simple is also called simple absolution, greatest form of ownership one can have, subject to eminent domain land use controls. Fixture is an object of the personal property before being affixed to the real estate in a manner that is caused it to be part of the real estate. A business may remove the trade fixtures, signs, counters, bar stools when its lease expires. Foreclosure process, for sales property, non-payment on claim. Freehold estate is an interest real estate with known termination date. When there is interest real estate with a presents termination date is called non-freehold or less than freehold. Homestead protections, family homes for creditors in certain instances such as bankruptcy. The dollar amount other than limits vary by state. Interest in real estate allows party certain use but less than fee simple estates. Intestate refers to a person who died without will. State law determines heirs. Intestate succession is a state law distributing property of someone who died without a will. If the descendants left no heirs, then the descendant property is sheets to the state. Joint tenancy is a form of ownership characterized by survivorship where one dies and the remaining joint tenants inherit the portion owned by the descendant. A license gives the person permission to go to another land for a special purpose. A license is also a privilege given by the state to a person to operate a real estate salesperson or broker. Littoral refers to shoreline property, a large body of water such as the ocean. Generally, private ownership stops at mean high water mark. Personal property, also called personality, is the thing other than the real estate. Prescription refers to the easement acquired by adverse possession. Property refers to legal rights to use, enjoy things. Layman terms of things themselves. Real estate, also called realty, refers to the land and everything permanently affixed to the land. Riparian refers to the land bounding the street, lake, or river. Survivorship is one of the co-owner automatically inherits ownership of the portion that belonged to another person who died. Tenancy of entries is a form of joint tenancy having survivorship that exists only within certain states, available only to husband and wife. It protects spouse rights to home for certain actions other than the spouse. Tenancy in common is a form of co-ownership of two or more people without survivorship. Each tenant is common owns the undivided interest in the whole or may dispose of his or her interest any way he or she pleases. Tenancy is severely of the ownership of the one person or one entity. This first chapter is subject matter material. Much of the written in this chapter we'll discuss in great detail in later chapters. However, we're going to summarize real estate law with the exemption of contract law and professional license. Subject matter of the chapter is very fertile. Source of license exam questions, particularly because of the concern of things of the average layperson knows little or nothing about, and manner of the examining authorities can make sure the successful licensing application and deed study of the laws and custom of the real estate business know enough about it to be worthy of public trust. Alright, property refers to legal rights to use and enjoy anything that, strictly speaking, the term property does not refer to the things themselves, but to legal rights that society allows someone with regard to the use and enjoyment of things. In practice, however, we tend to use the word property to mean things themselves. We do not think of it as odd for someone to say the car is my property to be absolutely proper. However, he would say the right to use and enjoy the car is my property. Where speaking of legal matters, it's essential to be precise and clear. You can land in serious trouble if the contract written vaguely with a description of a piece of the land is intact. The preparer can be held responsible for problems caused by the preparer's negligence. Property is divided into two kinds of property: real property, personal property. Respectively, these also known as realty and personality. Realty is the property rights of the real estate. Personality is the property rights of everything else, and personal property, it may be also called chattels. Real estate is defined land, everything permanent attached to it. A permanent attachment is anything that grows on land. B, anything that is built upon the land, including road, fences, as well as buildings. C, fixtures. Fixtures, items that may appear for the personal property, are considered to be part of real estate. Fixtures may include window, air conditioners, major appliances, drapers, and any other items of the nature. But there's no cut dried definition of the fixture, so many of the court disputes concerning real estate contracts involve misunderstanding concerning what are and aren't fixtures. Many objections can either be personal reality or personality, depending on how you use the brick. As personality unit is mortared into place into the wall of the building, at which time it becomes reality. A tree is realty when it grows. It becomes personality when it's cut down. When it's used building material, the wood becomes real estate again. Fixtures present gray area when an argument can be made either way as for the nature of them. Usually the courts decide such a problem based on the answer to the question. 1. How is the item attached to the property? The manner of attachment, annexation. The more tightly it is attached, the more likely the item will be considered part of the real estate. 2. What is the intention of the person who attached it? If intended for the permanently part of the real estate, then probably will be a fixture. 3. What are prevailing customs of a particular part of the world? Depending on the location, some of the things may or may not be considered fixtures. For example, in some places, major appliances, air conditioners, drapers alike are considered part of the real estate, whereas elsewhere the seller of the real estate would be considered perfectly with her rights to take them with her. Trade fixtures such as a business sign or bar stool may be removed by a tenant upon lease expiration. Both realty personality can be divided into intangible and intangible. We speak of the realty as these things referred to as incorporeal and incorporeal. Corporeal property is right to use, own, enjoy real estate directly. Term incorporeal concerns intangible, including rights to use property owned by another. Example, the easement rights of way, mere permission to use someone else's property. Corporeal property involved with the real estate is almost always real property, and corporeal property can be either real or personal property. Easements usually a real property. Short-term leases in most state leases of 1 year or less are personal property. Estates and land. And it states some of this of the degree of the quantity of the nature, extent of the interest has been in the real estate, with the estate divided into two great freehold and non-freehold. The basic differences of the freehold estate is if it's under certain duration become the extent of the owner's choice chooses to dispose of it, or if he does until he dies. We do not know how long that will be. The division of freehold estates are inheritable and non-inheritable. Non-freehold estates involve various kinds of leases. Leases are contracts with a specific period of time, or is known exactly when these kinds of estates will cease to exist. Fee simple estates are inheritable. Basically, they give the owner absolute right to do whatever they want to the land involved, subject to the owner general law with such eminent domain zoning and building codes. But most important, as far as the law is concerned, fee simple provides for the right to dispose of the estate in legal manner by selling it or giving it away willing to someone. Life estates are non-inheritable. In a life estate with arrangement, an owner called the life tenant has the right to either occupy and enjoy the property as long as he lives, but upon his death, the ownership of the property will be made to a predetermined person or persons referred to as a remainder man. Since the life tenant has rights of the property only so long as he lives, he has transferred to other only those rights. Consequently, he may sell his life estates to someone, but the person who have relinquished the property upon the original life of the tenant's death. Same would happen if the life tenant leased to the property someone and died before the lease expired. Furthermore, the tenant is considered to be a custodian of property. For the remainder man, he cannot allow the property to deteriorate beyond ordinary wear and tear because he must protect the remainder's interest in it. The special form of life estate that is called pure autre vie. This term is French, meaning for another life. In such life estate with a duration for not for a tenant's life, but for that of another's life. For example, I purchased a special built home to accommodate my severely disabled daughter, for the purpose to provide her with a place to reside with my son for the rest of her life. At which time I want the home to become property of a charity. But my daughter is legally incompetent and cannot own a real estate in her own name. One option that I would have to grant the home to my son per autre vie. The other life would be that of my disabled daughter. Charity would be a remainder man. My son would be the life of the tenant. As long as my daughter lives upon the death, the property would revert to the charity. Non-freehold estates include leases, specifically termed leases, and tenants that have the right, unless the contracts to give up, they sign with the otherwise dispose of the leasehold rights. If she had leasehold estates, furthermore, she has the right to occupy and enjoy the real estate during the period of her lease. An estate land requires that it has owner have the following rights: right to possess the land, right to use the land, right to dispose of his estate in someone else's possessions. Means basically just that: right to occupy the land, make use of it, and to exclude everyone else from the land. A person who has some of the rights of the land, but not all the possessory rights, is said to have the interest in the land. Interest occurs when a person has a month-to-month lease that either the party can terminate at any time, a tenancy at will, because he has no specific duration mentioned. Interest also occurs when the license to use is involved, but there has mere permission, not necessarily a written agreement that might occur with if someone asks permission to come up onto your land one afternoon to go fishing. Creation of estates and land. Estates and land are created with the following ways: will, descent, voluntary alienation, involuntary alienation, versus possession. One receives the real estate with a will if he inherits it, being designated by someone's will. This is all called a device. One receives this estate by descent if he is designated by law as a recipient of property of the deceased person. This occurs if the person dies intestate without no will. Every state has a law governing disposition of such property. Some of the states have dower laws, which are similar in effect. Dower laws state the person's spouse, sometimes his or her minor child, has entitled to receive the certain interest of his or her property when he or she dies. Most states have changed the laws and are in the process of changing them to give the husband and wives equal right to it in others' estate. Voluntary alienation is the most common means whereby a person receives its land. The terms refer to the voluntary exchange, sales, and gifts, wherein someone gives up the property to do something willing. Involuntary alienation occurs where the owner of an estate is forced in a legal manner to give up some of all her rights by action of law. This is most commonly occurs with the case of the bankruptcy having some of the other kind of legal judgment entered against one, foreclosure, failure to pay property tax. Involuntary alienation occurs with the foreclosure, e.g. eminent domain. See page 68. Adverse possession. Adverse possession is a special means of acquiring ownership. All states have the statutes permitting adverse possession, which are right of the person who have another land actual to receive a legal claim in the land. And the fee simple. The ancient idea behind this is that if the true owner is uninterested in the land and does nothing during the period of the time to prevent someone else from putting it to use, the community is better off by letting this other person actually have the full rights to the land. Adverse possession cannot be acquired overnight. Depending on the state, it takes up to 7 to 40 years to establish these rights. These adverse possessions must be open and notorious, exclusive, continuous, and hostile. This means that the claimant during the required time period may have acted completely as if the property were his own, including defining the rights of against encroachment by others and being open within his action. Adverse possession must continue throughout the statutory period. A person cannot use someone else's land for the summer of 1986 later in summer of 2016. This claims has been using it for 30 years. Further, no tenant can claim again his landlord, because every time the tenant pays rent, legally acknowledges that person receiving the payment is the true owner. Nor may one claim against the government on the theory that one is already a nominal owner of public property. Easements, see page 66, also acquired by adverse possession that are called easements or prescription. Tenancies. Estates led by may be owned with a variety of ways, depending on the number of people involved in the relation with the various forms of ownership are called tenancies. Tenancy with severity is ownership by one person or one entity. Tenancy in common is a form of ownership by two or more persons. Each one is involved with interest, which means he has his own fraction of each part of the realty. In this arrangement, each is entitled to a share of the property responsible to the other owners and share in the cost expense. No part of the land owned together may be disposed of without consent unless they have specific arrangement whereby less of the unanimity can force a decision. Tenants common need not own equal share of the dispose of the shares in a way that they choose unless they have specifically agreed upon limitation. Means that A and B may buy real estate tenancy common. Later B may sell his share to C, making A and C tenants in common. Further, tenant common will share his someone else or give it away. Joint tenancy is similar. Tenancy in common except that one important difference. Joint tenants have the right to survivorship. This means the joint tenant dies, her share is divided proportionally among the surviving joint tenants. Consequently, a joint tenant cannot will her share to someone else. However, he can sell or give his interest away, but the new owner will have the status of the tenants in common. Joint tenants requires four unities: interest, possession, time, and title. Tenancies by entries as possessional form of the joint ownership are allowed only with the married couples in the state, but when used, it protects the joint rights of spouses to joint own property, providing same basic right and responsibility. Joint tenancy will use while also protecting the property against the foreclosure due judgment of debt against one of the property's common property. Is a system that exists in a few states, including populous ones of California and Texas, where community property law exists. Half of the property acquired by the husband or wife during the marriage is considered to belong to each partner. These ownership rights transcend death and divorce. Community property states do not have dower or courtesy laws. All states have passed laws that permit establishment of condominium in the interest of the land. Condominium is a legal term describing a certain kind of ownership of the land. Does not refer to particular architectural style. In theory, any kind of property serving any use can be owned by the condominium in the form of the ownership. One has the title of the part of the large piece of property with the right to use exclusively the right to share some of the rest of the other owners. Typically, residential condominiums, will have the right to use his own dwelling unit, no right to enter the units are owned by others. However, the one would share the right while others to use common property, which might include the private drivers for the project, recreational areas, common hallways, and the elevators. Most important law allows all owner condominiums unit mortgage otherwise encumber in his unit. In default, the lien holder may force sale of the units by other owners. The condominium project cannot be held responsible for anything. Residential condominium development usually has a homeowner association, some of the similar group elected by owners of the own units units in the project. Function of the association ensuring the common property development and taken of, and always making enforcements where rules and owners as groups want to enforce within their private community. Many of the people have brought condominiums units have found later that the rules and regulations of the association not permit them to do everything they wanted to do. For example, the association may have the rule limiting overnight guests to more than 2 per unit, requiring only certain kinds of flowers to be planted in the front yards, and the owner who may wish to have the more guests plant different flowers can find herself a conflict association required to conform to the rules. Many condominium projects quite a lot of common property: swimming pools, parking areas, parking lots, bicycle paths, tennis courts, clubhouse, gatehouses. An example, owner units project with these common elements together as a group. Their association looks at common property, assesses each unit owner a fee called a condominium fee, usually a monthly, to get funds necessary to maintain it. Owner who does not pay the fee is usually fined that the association has the legal power to file a lien or a unit on his unit in order to collect the money. The cooperative form of the ownership existed much longer within the condominium, but it is very common outside of the major city, including New York, Miami, and Washington, D.C., when the cooperative of the real estate is owned by a cooperative corporation. Instead of owning a unit outright, the cooperative owner owns a portion of the share stock of the cooperative corporation, along with the right to a slew of the particular use and using called proprietary lease. Owners elect for the board electors responsible for the operation of the corporation. Therefore, for each of the property, each owner pays monthly assessment of the corporation, which in turn pays for the property tax, mortgage payments, maintenance, bills, and so forth. The big disadvantage Cooperative ownership is that if one or more of the owners does not pay, the others will have to make up the difference and face risks of having the entire property reclosed. All the forms of ownership just discussed have to do with freehold estates. There are two major types of tenancy that refer to non-freehold estates. Tenancy at will occurs when there is a lease agreement, but no specific time period is agreed upon. Essentially, then, either party can terminate an arrangement whether he wants, so its duration is unnecessary. Tenancy servancy occurs when the tenant remains a property after expiration of the lease. The difference with the tenancy that will, with often some that acts with the original lease contract, may be considered to be enforced, such as requiring notice before termination, prohibitions against certain kinds of use of activities by the tenant. Many states have it enacted requiring, even in case of the tenancy servancy or tenancy at will, the parties give one another a certain minimum notice before termination of the arrangement. Alright, homestead laws. Many states have what's known as homestead laws. They have a number of effects, some of which are similar to provide with the dower and courtesy referred to as probate homestead. In many states, the homestead laws protect one of the homes against a certain kind of judgments and claim. Usually, protection extends only to a specific dollar amount. The intent of these laws is to ensure that even under the most difficult financial circumstance, a homeowner will not lose their entire investment in the home. Limitation on the state's interest. Various estate interests complete free with a restriction and encumbrance in one or more of the following will affect them. The easements, restrictive covenants, or liens. Easements. An easement is the right of the own landowner to land belong to another specific purpose. For the two classes of the easement, for the prudency with the gross easement, prudent benefit, certain tract of the land, transfer of the land. Example, the easement, excess easement, if the benefit is of the tract of the land between, called domanial estate. Property use is the only one allowing with the easement and the surveying estate, and the title of the dominant domanial estate is transferred. Easement will benefit the new owner. Ease of gross benefit, specifically personal entry if it does not pass the land, rather remains on the specific owner of the example. The utility easement allows utility company to install, maintain, and repair its utility lines upon the premise of surveying estate. Benefits of the utility company. The surveying estate is transfer of the easement remains on the property of the owner. The most common kinds of the easement of the access easement, utility easement, and the drainage easement. All of these all allow someone who is not the owner of the affected property to make use of the property for some purpose. And access easement allows someone with one to cross the property to reach, obtain access to another property. The right to exist on one parcel of land is completely blocked by another from access public right away. Utility easement, right to hold the utility company to put the utility lines private property, usually for the purpose of providing service to the property. Drainage easement requires the property to not disturb the natural man-made drainage pattern that crosses its land. Easement created in this way with the estate of the most common, however, they are created voluntary alienation versus possession, which create with diverse possession. Easements are called prescriptions. Sometimes, some states, a person who sells a part of his land that does not have a direct access to public right-of-way is legally bound to provide a purchaser with an access easement. Restrictive covenants. Restrictive covenant is a contract whereby the group of the neighbor landowners agree to do or not to do with certain things, the things that usually mutual benefit. All covenants most commonly occur with the residents who, with the division of the creative of the developer, their homeowners association means assuring the protective respective by of the development will require to meet the certain standards. Example, the covenant prohibitions against using a lot or more than one single family dwelling, limitation minimize size structural to be built, specification architectural style. In some states, with the entire collection restriction apply to the subdivision called the bill of assurance. Also, in some states, restrictive covenants are called deed restrictions. Some properties refer to them as conditions, covenants, and restrictions, or CCRs. Liens or claims against the owner of the property, with the property being used unsecretary with a claim with a mortgages or liens, claims of the unpaid property tax or liens. Also, anyone who has done work provided material with the enhanced value of the property, if not paid on time, secure with a mechanics lien against the property. If the liens are not paid in legal manner, holder of the lien can foreclose against the property. Foreclosure is the legal process whereby the person holding the legal claim against the property may have the court ordered for the property to be sold as to provide the funds to pay the claim. Liens, restrictive covenants, and easements are legally speaking a part of the property cannot be separated without consent with all the parties involved. With the person who considered the buying property must be aware of the purchase. Does not remove these. All of the encumbrances of the property will remain after they acquires the title unless something does to remove them. Water rights. Riparian refer to property holders, property borders of water such as rivers, streams, and lakes. The owner of such property has riparian rights. Most state riparian rights owners cannot accelerate or detain the natural flow of water. Many western states also use usufructuary rights, whereby an owner may divert a stream for a beneficial purpose such as water growing crop. Littoral rights are held by the owner's commercial navigable body of water, lake, ocean, sea. Generally, private ownership ends with the meeting of the high water level. Accretion and erosion. Accretion is increase of the land for the process of the nature of sudden change of the water course can result in loss of soil called avulsion. Increase of alluvial deposits called alluvium or alluvium. Alluvium or alluvium. Erosion gradually wearing the land of the process of nature so that the erosion may cause substancy. This could result in loss of lateral support with the building and diminishing in structural integrity. Title recordation. A person who owns a real estate is said to hold the title on the land. There's no such thing as the title papers of the real estate, but there are with automobiles, certain other chattels. The term title refers to validity, available evidence to back one's claim to the land. Normally, all deeds and items, deeds, liens, restrictions, easements affecting the land are recorded, usually in the courthouse for the county in which the land is located. Some leads for the contract sales of the documents may record as well, but the object of the recordation provide for the means whereby anyone check validity any claim of land legal sense. Therefore, the ownership of the land, right to the land, should be the matter of the record. The records are public with the means of anyone examining them. Also means anything in the record gives everyone constructive notice of the information recorded. Therefore, within the court of law, one is assumed to be aware of all the information in public records. The total evidence for the records will be validity of the title of the owner's hold. The title is the title that cannot be impeached by the records. This title appears to be good, is said to be colorful title. Eminent domain and escheat. There are two special ways the government may acquire title or real estate, but the most important is eminent domain, the right of the government to acquire the property of the owned, the property to public use. Even if the private owner is unwilling to depart with it, government needs this power in order to operate efficient benefits for everyone. Imagine the power problems if the government decides to build a road and to look over the find willing seller for a land near need for project. The road might wander all around and quite possibly couldn't be built at all. In an eminent domain situation, over the government can't seize the land, it may depart over the owner's just compensation, generally considered the fair market value of the land. However, once the government has established the needs of the land for legitimate public use, there is no way to stop it. The landowner can do its dispute over the price being offered. If he thinks it's unfair, he may sue with a higher award and have the court make final decision. Usually, the government will approach the landowner to work out the admissible arrangement, and quite often the landowner agrees to offer the price if there is no dispute. If, however, the landowner is reluctant to or refuses to negotiate, the government will condemn the affected land and condemnation of the legal process whereby the owner is dispossessed of the property and must leave. He retains the right to dispute the price being offered, but one condemnation has begun. At the time will come to when he must leave the land and will be transferred to the government, whether or not to pay. The question has been settled. All levels of government has power eminent domain. Also, many states have granted limited eminent domain power to private enterprise, such as railroad utility companies. This sheet is a process whereby land which no legal owner exists reverts to the government, which can dispose of it and use it as it sees fit. A sheet may be most commonly occurs when someone dies intestate and no legal heirs can be found. Alright, your real estate laws. Let's just, chapter 3 questions. I'm going to cut the tape there.